What's up, everybody? Happy Monday. We are back with another Sarah Boone update. She's actually in court with her newest attorney. So we get a look at him. And some of the things that I'm interested in is, will he talk about the fact that Sarah Boone and he have had any discussions yet? Will he have any complaints about her? Will she have any complaints about him? Do they have a plan? Is he going to continue with the battered spouse syndrome defense? Are they going to set a trial date? Are they going to set a status conference? It's only a 3 or 4 minute video, so it's not very long. My guess is they're just going to kind of set it out to make some more decisions later, but I'm interested just to see the interaction between them, see if Sarah Boone seems any happier, see if any issues have arisen already, and if we can get a vibe for how this relationship is going to go. Obviously, if you're Sarah Boone at this point, you realize you're treading on thin ice, and if you can get a lawyer that's willing to help you and do a good job, you need to work with that lawyer and try to get this case prepped for trial so that you can tell your truth and see if the jury agrees and if you can go home to your son, or if the jury doesn't agree, but at least there will be some finality. So let me know what you guys think in the comments as we watch this video together. Hit that like button if you haven't already. Subscribe to our page. Hopefully we get this case to trial sooner rather than later so we can see if we can get some justice for the victim in the case, whether that is that Sarah Boone did this and should be convicted of it, or whether it really was truly an accident, depending on what the jury decides. But let's get to this hearing now.
Move Ms. Boone to the center seat and swear in.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Welcome back, ma'am. Tell me your name and your date of birth.
Sarah Boone, 10-10-77.
All right. In this case, you were most recently represented by Mr. Bankowitz. I granted a motion to withdraw. We appointed Mr. Hobson, and we set a status hearing today. Mr. Hobson, where do you stand as far as entering the case, and how much work do you think you have to get done to get the case ready for trial?
Let me start. I'll start at the back end, Judge. I would ask the court to set a status for sometime in January. I've had discussions with Ms. Booth before today, and she's okay with that, and I think that would make sense. I've got like a banker's box and a half of stuff I'm trying to wade through, plus.
So a couple revelations there right off the top. He has had multiple conversations with Ms. Boone at this point, which seems to be a better start than she and Frank Bankowitz's attorney-client relationship. And she has agreed with this attorney to push this case out until January for a status conference. Now, there's a couple reasons a client could agree to that. Number one, the lawyer could say we don't have a choice. Or number two, the lawyer's actually working with her and saying, listen, I've got a banker's box and a half full of stuff I'm wading through. So I'm going to continue to go through that. We will continue to talk about it. We'll continue to prepare your defense. We'll work together on this. And I will be able to tell the court some real details in January about, do we need an expert? Are we going to go with the battered spouse defense? When can we set this case for trial and actually pick a trial date that is a real trial date where we actually do have a chance to go to trial? So to me, sounds like it's getting off on the right foot.
The media stuff. So
and media
I think
stuff
that would be the best option we've got right now, as far as I'm concerned.
So I don't have my dates other than my pretrial and trial dates for next year. I don't have the calendar ironed out. Okay. But what I could do is just give y'all a January pretrial date, understanding that you're not representing that you're actually going to be ready to announce trial. But at least it's a next point to see how far you've gone, how much further you have to go.
So interesting caveat there. So it is going to be a pretrial date, but they're not actually going to be required to provide a date that they'll be ready for trial, which indicates there will be further delays. Because usually if you're going in January, you'll probably pick a trial date and set that trial within the first half of 2024. But if it's really just a status conference, probably another couple months before you set the real pretrial to pick the trial date, pick all the discovery cutoffs, and kind of work backwards from that trial date. So now it's looking like we're probably maybe another 12 months out before we get a trial in this case. And that's probably on the good side.
My hope would be in January, you'd be able to give the court a realistic estimate of when you would be ready to announce trial.
Yes, sir.
In January, you'll give the court a realistic estimate as to when you will be ready to announce trial, not to go to trial, but when will you be ready to say, I'm ready 6 months from now? That's how this process works. And you got to listen to these words because delays are going to continue to come for Sarah Boone.
State, are you okay if we handle it that way?
Yes, that sounds reasonable.
State's like, we'll be here.
I have a January 16th pretrial date. Is that far enough into January, Mr. Hobson?
Yes, sir.
All right. Here's what we'll do. We will set pretrial conference on January 16th, trial period January 29th. The one thing I'm going to ask Mr. Hobson is if
That trial period, January 29th, is purely a placeholder. They're not going to trial then. Doesn't matter what anybody reports. I'm telling you right now, there will not be a Sarah Boone trial starting January 29th. Absolutely not going to happen. One of the kind of dumb things that happens in legal planning and processing is when you get a pretrial, it's connected to a trial period. It's just not how it's going to go. I would be shocked at this point if we had this trial in the first half of 2024. It's possible, but much more likely the second half of 2024.
there are particular problems with the discovery, getting up to speed that you know about before the 16th, if you could bring those to the court's attention beforehand,
Yes.
so we can at least start working those problems as they arrive, that would.
So what he's saying there is, as you find things out, if you need things from the state, if there needs to be a motion to compel, if you need to do some depositions, if you need to hire an expert and you find out we need to redo that hearing asking for additional funding, don't wait until January to tell me we've got to deal with those stuff. If you know we have those things coming and we can pick a date in December to deal with them, let's deal with as much as we can, as quick as we can. So I appreciate that out of the judge, that we don't need to wait to January to do anything in this case. Hopefully over the next month or two, you'll be able to get your arms around. A banker's box and a half of documents is really not that much. So hopefully you'll be able to get your arms around that stuff sooner so we can get this case moving.
Would be my request.
Okay.
All right.
I would also ask the court as a caveat to indicate that it's a pretrial conference / status conference.
Sure.
So-
Have the court minutes reflect.
So he wants the court minutes to reflect that we're going to set a pretrial conference / status conference. So again, and sometimes this happens, the judge has lots of cases, state has lots of cases. If somebody forgets what they agreed on, he's like, let's have the court minutes reflect that this is not a pretrial where we are going to trial. So we don't have to file a motion to continue and try to continue this trial and all of that, so that we know it's just a status, that in the future we will be setting this trial. Because again, everybody knows this case is not going to trial on January 29th.
That I'm setting it for pretrial conference / status for the defense to advise the court how long before they are prepared for trial. I think speedy trial was waived long, long ago.
4 years on, Judge.
Okay.
I couldn't hear what the lawyer said. I'm going to back it up, but that's a question a lot of people have had. I heard speedy trial was waived long, long ago. And the answer to that is yes, unfortunately. Sarah Boone has admitted that in some of her letters, but she said that it was done unknowingly, like she didn't know or it wasn't appropriately explained to her, which potentially could be a motion the lawyers would file, but it doesn't seem like that's going to happen in this case. I'm going to back it up a little bit and turn it up to see if I can hear what that lawyer's response was to that.
Speedy trial was waived long, long ago.
4 years on, Judge.
Okay. So I'm just going to court reset.
I think he
it for
said
those
before
dates.
I was assigned, Judge. I think that's what he said, before I was assigned. So speedy trial has been waived. A lot of people have been asking about that. So just so it's clear and on the record, and that's why the judge is saying it, so that it's on the record that everybody knows speedy trial has been waived in this case.
Anything else I need to do on Ms. Boone's case today?
Nothing else, Your Honor.
All right. Ms. Boone will be returned to the Orange County Jail pending disposition of her case.
Yes.
you.
Thank you, Judge.
All right.
That's all I have.
Okay. Have a good day. Ms. Vega, are you ready on Hope? All right, let's call up Hope.
Yeah.
So a little smile, a little thank you, a little handshake. I mean, I think that's the happiest Sarah Boone has been in the courtroom with any of her lawyers here so far, because it seems like this guy is at least talking to her.
Ready on Hope.
Yeah. I mean, to me, it's about as good as it's looked so far for Sarah Boone in her case, in her attorney-client relationship with all of the different attorneys that she's had. So an uneventful hearing, but at least we know there are still going to be a lot of delays. We don't know whether battered spouse is still going to be a thing. But this lawyer at least is talking to Sarah Boone. We await her next letter to give us a little inside information of what's really going on from her perspective. Hopefully you guys enjoy it. We are going to continue to follow this case It is in Florida. A lot of cases in Florida, which is always wild, but I appreciate you joining me. Hit that like button if you guys enjoyed it. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed this episode, please hit the thumbs up and share with your friends who might be interested here on YouTube. And of course, don't forget to subscribe to our channel. You can also follow us on all social media, Twitter, Facebook, TikTok, @LawyerYouKnow. But on Instagram, we are still @TragosLaw. So look us up on there. And don't forget to listen to the Lawyer You Know podcast, available on all major podcast platforms. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us lawyeryouKnow@gmail.com. Of course, all of these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.